wrong to us that my voters are now disenfranchised but in a national election where other states didn't follow state law. In this case, these states had different rules in different counties favoring one candidate over another, and we don't know now how credible those mail-in ballots were.
So what is Paxton asking for? He's asking the Supreme Court to throw out the results of the vote in those 4 states, and rather than seating electors on Monday to vote for president, throw all of that over to the legislatures in those states to determine which electors should be seated, electors for President Trump or electors for Joe Biden. It just so happens, too, Harris, that in those 4 states, both the Houses and the Senates are controlled by Republicans, which would likely mean that electors for President Trump would be seated, thus potentially overturning the results of the November 3rd election. We'll see how this goes before the Supreme Court. As you mentioned, the defendant states have to file briefs by 3 o'clock this afternoon. We may get word from the court as to whether or not it will accept the case later on today.
A judge declares independence not only from Congress and the president, but also from the private beliefs that might otherwise move her. The judicial oath captures the essence of the judicial duty the rule of law must always control. My fellow Americans, even though we judges don't face elections, we still work for you. It is your Constitution that establishes the rule of law and the judicial independence that is so central to it. The oath that I have solemnly taken tonight means at its core that I will do my job without any fear or favor, and that I will do so independently of both the political branches and of my own preferences. I love the Constitution and the democratic republic that it establishes, and I will devote myself to preserving it. Thank you.
The state of Texas filed a bill of complaint with original jurisdiction to the Supreme Court of the United States. What that means is the case does not go through the district court, the Court of Appeals, and then to the Supreme Court. It starts at the Supreme Court. That's because the state of Texas has filed a lawsuit against the Commonwealth of Pennsylvania, the state of Georgia, the state of Michigan, and the state of Wisconsin. So those cases have original jurisdiction. That was filed Tuesday. Yesterday, the president intervened, filed a motion to intervene. He hasn't intervention hasn't been granted yet, because he's what's called the real party in interest, and it impacts him. None of these cases call for a determination of the outcome of the election, by the way. But that was filed yesterday, a motion to intervene on behalf of the president. And then about the same time, maybe an hour before, 17, maybe 18 states now have filed friend of the court briefs, either supporting Texas totally or, in Arizona's case, saying, look, we're not going to get to the merits, but we think it's important that you hear this case, and we believe your jurisdiction, state to state, is mandatory, not optional.
If we go back to Arizona versus California, a decision taken in 2020, this year, Justice Thomas and Justice Alito both agreed that the Supreme Court's original jurisdiction in this particular case is mandatory. It's not optional. So that would mean that the Supreme Court has to take this case, has to consider this case, and has to decide this case. Now, it's not clear that a majority of justices of the United States Supreme Court agree with that position, but I think Justice Thomas and Justice Alito have the superior constitutional argument, and it's very, very important that the state of Arizona has filed a brief in support of that notion, and we will have to wait and see whether the Supreme Court majority agrees with that. But major constitutional issues affecting each and every citizen in each and every state are at risk with respect to whether or not the Supreme Court takes this case. Otherwise, the Supreme Court effectively, not necessarily intentionally, would unleash administrators, the executive branch, to violate the Electors Clause of the United States Constitution. So this is a very, very important series of cases.
Like in Bush versus Gore, there was going to be one case that would be outcome determinative. We, I think, have clearly reached that outcome determinative case right here.
The allegations made by Texas and supported by these 17 other states that I rattled off their names has got nothing to do with election fraud or election rigging or anything like that. What it is saying is very simply this. Each state needs to conduct its election laws in accordance with the laws mandated and passed by the legislatures of those states, okay? That's what our federal system is about. Remember, this is a federal union. That means everybody does things according to the law, and that was what binds us together. What Texas is saying is that Wisconsin and Michigan and Georgia and Pennsylvania violated their own state laws in doing things in a fashion that was improper. And only the legislature under the Constitution can set the manner and the means by which electors are chosen. Non-legislative actors like the Secretary of State in Michigan, who took it upon herself to send out 7.7 million absentee ballots when Michigan law does not permit her to do that, violated the law. When in Georgia, I'm sad to say my state, the Secretary of State entered into a settlement agreement with Stacey Abrams and the Democrats that said you don't have to verify a signature with the voter registration card when state law says you have to. Who are you, Brett Raffensperger, to do that? What authority did you have to do that? State law says the contrary. You have no business violating state law, and that's what Texas says. Therefore, the 62 electors in these states.
And again, I want to underscore that we're not talking about disenfranchising. People are saying these lawsuits are disenfranchising, 100 million voters, or 250 million voters, or 300 million voters.
No,
actually, it's not disenfranchising anyone because the states will still put up electors if the state of Texas is careful. But how many is involved?
62.
62.
That makes a difference in the outcome. The legislatures now need to step in. That's the argument that's being made. And to say, look, this is the way you elect the slate of electors, consistent with state law.
The key distinction is between executive branch decision-making and legislative branch decision-making at the various states. So, pursuant to the United States Constitution, it is up to the state legislature to set the terms of an election in each and every state. That's number one. Number two, once those terms have been set by the state legislature, those terms cannot be varied except by the state legislature itself. Any other change, in my opinion, is arguably unconstitutional on its face. And so what the state of Texas is arguing is that these defendant states, Georgia, Wisconsin, Michigan, and Pennsylvania, they engaged in, if you will, executive/administrative branch misconduct. That misconduct, standing alone, dilutes the votes of citizens in each and every other state. So in 46 other states, their votes were indeed diluted.
The case is entitled State of Texas versus the Commonwealth of Pennsylvania, State of Georgia, State of Michigan, State of Wisconsin. It's case number 220 for original 155. Case of original jurisdiction on an election. This is the moment. This is the case. We said there would be one. This is the one that will be outcome determinative, in our view. Doesn't mean these other state court cases stop, but this is really the ballgame right here, in our view.
President Trump is meeting with a group of state attorneys general right now at the White House. It comes as the president and 18 states are now throwing their support behind a Texas lawsuit. That suit is seeking to overturn the election results in 4 battleground states. States have until 3 p.m. Eastern today to respond. Chief White House correspondent John Roberts was live for us outside the White House. John.
Harris, good afternoon to you. 12 Republican state attorneys general joining the president for lunch today. This meeting was scheduled before Texas State Attorney General Ken Paxton filed a suit challenging the election results in 4 states with the Supreme Court. Paxton was here today, as were the attorneys general of 10 other states who have joined that case. The latest one joining just today being Arizona. President Trump himself also joining that case in a statement put out by the campaign last night saying, quote, the president intervened because his rights as a candidate are affected by the defendant state's failure to follow and enforce state election laws during the 2020 election. This is a case that the nation is going to be watching very closely because it's thought that it may have the best chance of anything so far of being accepted by the Supreme Court, because this is Texas seeking relief from other states. It goes right to the Supreme Court and does not make its way through the lower courts first. The Texas Attorney General Ken Paxton asking the court to throw out the vote in 4 states, Pennsylvania, Georgia, Michigan, and Wisconsin. Paxton insisting that those states adopting mass mail-in voting broke the law and therefore had a negative effect on Texas voters. Listen to how he put it.
It seemed wrong to us that my voters are now disenfranchised in a national election where other states didn't follow state law. In this case, these states had different rules in different counties favoring one candidate over another, and we don't know now how credible those mail-in ballots were.
So what is Paxton asking for? He's asking the Supreme Court to throw out the results of the vote in those 4 states, and rather than seating electors on Monday to vote for president, throw all of that over to the legislatures in those states to determine which electors should be seated, electors for President Trump or electors for Joe Biden. It just so happens, too, Harris, that in those 4 states, both the Houses and the Senates are controlled by Republicans, which would likely mean that electors for President Trump would be seated, thus potentially overturning the results of the November 3rd election. We'll see how this goes before the Supreme Court. As you mentioned, the defendant states have to file briefs by 3 o'clock this afternoon. We may get word from the court as to whether or not it will accept the case later on today.